Support comes from Sunday Morning Cafe, founded by researcher, speaker, and therapist Dr. Tom Wagner, offering mini retreats with live music and online resources to build resilience and community. SundayMorningCafe.com.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fenske. What responsibility do judges have to keep their opinions to themselves, even when they're discussing items that have little to do with the cases before them? And can one company stop another from pursuing a new line of business just because their names are similar? And what responsibility do event organizers have for the actions of security staff? And does it matter if the organizers are public officials or private citizens? Those are all good questions for good lawyers, and we have three with us here today. Yes, today is our legal roundtable. We've got a great panel, and today that includes Nicole Gorofsky. She's a former prosecutor in both state and federal court, and she is now a partner at the Clayton firm Frankel, Rubin, Klein, Payne, and Podlowski, PC. Nicole, welcome back.
Thanks for having me.
And we're also joined today by Eric Banks. He's a former city councilor for the city of St. Louis, and he is now an attorney and mediator at Banks Law. Eric, welcome back.
Thank you.
And last but never least, we are joined today by Beavis Schock. We've been trying to get Beavis back on this program for a while. He's a fan favorite, and he joins us today. He is in private practice in Clayton at Schock Law. Beavis, welcome.
Thank you, Sarah.
So, Beavis, this is particularly good timing because you had a big victory before the Missouri Supreme Court this summer. Now, this involved a man, your client, wanted to grow rows and rows of sunflowers in his lawn. St. Peter's cited him. It said his lawn had to be 70% grass. But the issue that you won before the state's highest court wasn't about whether he could grow sunflowers. It was about whether he had the right to a trial before a jury of his peers. Don't we all have the right to a jury before our peers? What was happening here?
Okay, so the first thing, Sarah, is that it was not in the Supreme Court. It was in the Missouri Court of Appeals, and the other side, after they lost, did not take it to the Supreme Court.
So it's as if the Missouri Supreme Court has given its blessing.
Well, yeah, and it's a pretty strong case. Chris Bank likes sunflowers. I mean, the guy sitting in my house said, why the sunflowers? I like them. And when I talk to people around town about this case, they say, well, if you want to have sunflowers in your front yard, have sunflowers. There's a real sense of a person's right to have the flowers they want in their front yard. It's just not something that the city needs to be worried about. My client got charged with plants too many. That's how I phrase it.
Plants too many.
That's how I phrase it. And he went to trial in the St. Peter's Municipal Court, where he was found guilty.
Of plants too many.
Plants too many. He immediately that night filed what's called a Latin term, trial de novo, a new trial in circuit court, which means you go up to the big courthouse in St. Charles. And I asked for a jury trial because I think that was the right thing for this case, because maybe the jury will say, I don't care if you proved it. We're not finding him guilty because it shouldn't be against the law. That's a separate day for this matter, for this group. The judge denied the jury trial, and I asked the higher court, the Court of Appeals, to make the trial court give us a jury trial. Now, the old saw had always been, the prosecutor's not asking for a jail time, so no jury.
And when you say the old saw, this was just kind of pattern and practice?
This has been going on for a long time in this community. Oh, Judge, I don't want jail time for this schmuck, so let's go with no jury. And I said, no, that's not right under Missouri law, and I cited chapter and verse of various constitutional provisions, and just delighted with the outcome. We get a jury trial in his case, but also everybody who's a defendant in municipal court who actually goes to trial before the municipal judge, Richmond Heights, Ferguson, Afton, doesn't matter where, or down in Jefferson County, anywhere you want. If you go to trial and lose, you file this thing, a trial de novo, Latin, which means new trial. Mm-hmm. It doesn't cost anything. It's on a little form. And then you get your jury trial. And this changes the dynamic between prosecutors and defendants, because prosecutors normally get to just run roughshod over these people, and now these people get to run roughshod over the prosecutors because the prosecutor doesn't want to spend a day and a half on a jury trial on a traffic ticket or something. Now, the more serious matters, DWI, an accident, these things will get a jury trial, and they should, unless the person wants to plea out. But this changes the power dynamic between the prosecutors and the defendants in favor of the defendants.
So, Nicole, you have been a prosecutor. I'm wondering if you would agree with Bevis's analysis. I know you would never say a word like schmuck, and you might not express it the way that Bevis has expressed it, but do you think he's right that this changes the power dynamic in a fundamental way for these cases coming out of municipal court?
I mean, on each individual case, no, right? Because prosecutors are willing to do jury trials. But when you look at it on a grand scale, I mean, if every municipal person decided to come and ask for a jury trial, it's not economically sound. Prosecutors would be overwhelmed. Yeah, I think in that sense, it absolutely changes the dynamic.
And do you think with, a case like this where we've got sunflowers, is that fundamentally a different case when you're a prosecutor trying to bring that, if you're bringing it before a judge or if you actually have to deal with a jury? Is it
Absolutely.
more than about that length of time? Obviously, impaneling a jury takes time, but just trying to make that argument.
Absolutely. Your entire preparation is different. You're not making an argument to a judge. You're making an argument to a jury. You have to prepare for the way, people generally think, people who are not necessarily schooled in, the black letter of the law. So absolutely, it changes the way you prepare for the case, changes the way the case, can turn out.
Eric, it sounded like Bevis was almost talking about jury nullification, that, you or I are jurors in this case, and we're going, I don't care what the law says. Let the guy have his sunflowers.
Well, jury nullification is alive and well, and I'm not convinced it's a bad thing. I think that it gives the jurors the right to view the scene from 50,000 feet and with all the things considered, make the ultimate decision that they feel comfortable with.
Yeah, I agree with that. I was just reading a story on the KSDK website where they were talking about Cori Bush's husband, where federal prosecutors had brought this case. Ed Martin, sort of a known quantity in St. Louis, had brought this prosecution. And the testimony from this juror was that a lot of jurors were just like, yeah, tell these guys to pound sand. We're a D.C. jury. We're not in favor of what Ed Martin is up to. Maybe the facts of what the person did don't matter as much as whether the jurors think the law is a good law. Bevis?
Well, I love jury nullification. The big question, jury nullification means that if the prosecutor proves the case, the judge has instructed the jury, if the prosecutor proves the case, find him guilty, the jury still finds him not guilty, which they have an absolute right to do, and then that's called double jeopardy. The case is over. It can't be rebrought. The big question is whether in a case like mine, I get to tell the jury, hey, even if the prosecutor proves it, this is the kind of thing that shouldn't be against the law. Defend the right of the property owner to put whatever sunflowers he wants in his front yard and find him not guilty and let's go home, which now you can't say. And we may do a writ on that one. I've actually written a 35-page brief going through the history of the Constitution on the issue, and we're going to get that filed pretty soon in this case.
What do you mean you can't say that?
You cannot say to the jury, even if the prosecutor proves it, you should find him not guilty, because the prosecution is not the kind of thing that we want in our society, that this conduct shouldn't be against the law. So under jury nullification, the idea is that the jury, acting on behalf of the people, acts as a check on the legislature, which adds another piece to the chessboard favorable to the people.
But so right now, juries kind of have to read between the lines. They have to go, we could just nullify this whole thing. You cannot argue to them to do that?
That's correct.
Nicole, again, former prosecutor,
Yes,
I'd love to hear your
course.
perspective.
And so, in fact, they're not even supposed to read between the lines. They're given a set of jury instructions that tell them the law, and they're supposed to follow those jury instructions.
Sure.
I mean, so I'm going to be the lone person here coming out in favor of not having jury nullification. I mean, jurors are not supposed to be the legislature. That's what we have a legislature for. And so I am not a fan of jury nullification. And in fact, as a prosecutor, did many, and even as a civil attorney, done many what are called motions in limine ahead of time before trial, saying that the judge should prohibit the opposing counsel from arguing for jury nullification, because it's just arguing to the jury, you should not follow the law. Of course you're not supposed to do that.
Well, we've had some unjust laws in our country. I don't know. Eric, you want to jump in here?
Well, I'm cursed with the ability to see both sides of the argument. Yeah, jury nullification is technically wrong, but it happens every day of the week. And if they had trials on Sunday, it would happen twice then.
So Beavis is talking about, 35 pages? Is that what you said? You're writing a lengthy argument here, and erudite, no doubt.
Well, we'll see. It's a very tough battle. Jury nullification was assumed at the time of the founding. It went away in the late 1800s. The people who are in favor of it think that simply talking on the radio about it like this lets the jury know that they have a right to ignore the judge's instruction, which Nicole is absolutely correct that the jury is supposed to do it. But now I like the idea of the people being one last check on the legislature. So she doesn't. That's okay. Respectful disagreement among colleagues. But we'll see how it goes. I mean, it's a tough road.
I was going to say, let's take a bet right here on St. Louis Public Radio. I don't think you're going to win that one.
You think odds are against Beavis's motion?
Yes, 35 pages or not.
Eric, you get to be the tiebreaker here. Do you think Beavis has a chance in heck to win this motion, and he gets to openly advocate for jury nullification?
No, I don't, but he needs to make it anyway.
I like that fighting spirit. Beavis, we're going to demand an update on this case as it continues to play out, and it sounds like you will be there fighting this for your sunflower planting clients.
Absolutely.
So I want to talk about a different and a potentially more serious case. So protesters have sued Congressman Wesley Bell. This is over a town hall that started wild and then it got violent. This was 1 year ago. It happened at the old Post-Dispatch building. After Bell left the stage at this town hall, the lawsuit says the security that had been hired for the evening, quote, violently and aggressively removed people from the room. One was pinned against the wall and grabbed by the throat. Another alleges that he was thrown to the ground. Bell's security detail, they're accused of assault and battery. This suit also accuses Wesley Bell himself of negligence. Eric, what strikes you about this case?
Well, the fact that it was in a public building and not a federal or a private, it was in a public building, not a private building, not a federal building, government building, anything of that nature. And regardless, the optics look bad because I saw, as I'm sure the rest of the panel saw, that Goliath of a fella manhandling that small woman. And quite frankly, that's all I need to see.
Yeah.
That's all I need to see. He was wrong for that.
Yeah.
And people in that capacity don't have the right to lose their temper. And it was plain that a lot of the security, they just lost their temper. Now, did the people behave badly? Of course they did. A crowd does not have the right to interfere with the speaker. And Wesley put up with it as long as he could, I guess. But the forces, the power structure just unreasonably overreacted on this one.
So my colleague Ryan Kroll was at this protest, and he was texting me throughout the night. He was like, this is unbelievable. I've never seen a town hall that is this out of control. Here's some quotes from his story. Protesters outside the building beat drums. Protesters among the crowd inside turned away from the stage at times and hurled insults towards those standing on it. One veteran political reporter noted that she'd never seen anything quite what was like unfolding in front of her. Beavis, does that matter legally?
Probably not formally. I know that the plaintiff's counsel, who I talked to this morning about the case, hopes that that doesn't become part of the story, but it will. And I think the public understands that by making noise and beating drums and preventing the speaker from speaking, they did absolutely the wrong thing. Nevertheless, you can't grab a little lady by the throat. The big question in the case is whether Bell has any liability. Who were these people working for? Had he already left when that happened? I think he had. So it's going to be pretty tough to pin it on Bell. Now, apparently, just say one more thing here. He says that Bell promised them that, he said, if you'll shut up, I'll come talk to you later. And then he broke the promise. True, not true, I don't know. That's the allegation.
So let's say that Bell did leave the event, but this was an event he hosted and hired the security for it. Does that mean he's still responsible for the security? Does it matter if he left the event? What's your take on that question, Beavis?
I think he's probably not responsible if he had left, unless he told him, hey, beat these guys up. I really kind of doubt that.
Yeah.
I think they're going to have some security people that are in trouble, and Bell kind of walks away. And look, the whole thing is so politically driven. I mean, we're 2 weeks from the election, whatever it is, a week now. That's what's driving the train.
Well, yeah, it is fair to say that we are less than a week from the election, and Bell's people have fired back with a statement, saying that this is, they did not do anything wrong here, etc. Nicole, what's your take on whether Wesley Bell could be held responsible? Let's say he just hired a firm. It wasn't like he personally recruited these people. He didn't personally train these people. Is that different than if he had?
I mean, I think it's a very, very much an uphill battle to make Wesley Bell responsible for this. But I mean, I think they will at least get the opportunity to look into the facts and try to, prove what they can. I mean, what kind of instructions did Bell give these security people? What, how much control did he, maintain over them? All of those kinds of things will be looked into, and that will be an issue. But in the end, I think it's an uphill battle.
Okay, let's say for the purpose of the argument that Wesley Bell did not give instructions. He's probably focused on, how am I going to handle this on stage? What if somebody who directly worked for him, some campaign manager or something, gave instructions like, okay, it's time to let the dogs out, or something like that? Is he responsible for that?
Yeah, see, then you've got kind of a double respondeat superior issue of trying to look at how responsible was Wesley Bell for that staffer. And yeah, I mean, it's going to be heavily factually intensive.
Eric, is this a case you would take on behalf of these plaintiffs?
Absolutely not.
Because it's a bad case, or because you don't like how disruptive they were?
Both.
Okay. You can choose your cases, right?
Yeah, that's right.
Beavis, what about you?
I wouldn't take it because I don't think there's going to be a payout. These security guys won't have any money. I suspect Bell doesn't have any liability. I think it's an absolute strong liability case. The plaintiffs are really good people. There's no ability to pay. So I would say probably not.
And that's what they do not teach you in law school.
But is kind of the number one question that lawyers ask themselves.
That's fascinating. Like, why do they not teach that in law school? That feels like a very practical, important thing, that there should be, the question of case selection 101, or maybe that's a 300 level course. Why is that not something? Are you guys are too theoretical?
Law professors do not practice law.
That's true.
Doctors learn medicine from doctors in the hospital practicing. Law professors don't know anything about it.
This is fascinating. And this is, I think, why when I have had law professors on the show, I'm sometimes not as pleased as when there's certainly exceptions to that. But I like that you guys are out there practicing. You're in the courtroom making these decisions.
The dean of my law school said our first week in August of 1977, every student at this school deserves to be treated equally and with a lot of respect, because the real smart students go on to become law professors. The moderately intelligent students go on to become judges. But the run-of-the-mill law students go into private practice and make all the money that eventually funds the law school to begin with. So we want to treat everybody fairly at the school.
This sounds like a law professor's perspective on the law. And we should also note that there are plenty of attorneys who will choose lower-paying, mission-driven work. Eric, I know you just joined the board for Legal Services of Eastern Missouri. Like, you're out there volunteering your time to help an organization that maybe is making a different calculation of when it will choose to take a case.
And they are extremely diligent in their screening.
Yeah. They're also looking for a good case.
Yeah, they are.
We're talking today to our legal roundtable. They are throwing down on what it's really like to be a practicing lawyer. This is why I love having these guys here. And that includes Eric Banks, Nicole Gorofsky, and Beavis Schock. We're going to take a quick break. Coming up next, Dr. Browns versus Dr. Browns. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from Mosby Building Arts. Mosby transforms unfinished basements into comfortable spaces for relaxing, entertaining, and spending time together. Make the most of your square footage. July basement sale. Details at callmosby.com.
Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our monthly legal roundtable. We convene 3 top lawyers in town, and they will share freely their thoughts on the legal matters that are in the news. All those things you wonder, like, are they allowed to do that? They will tell you whether lawyers are allowed to do that, whether judges are allowed to do that. Today, our panel includes Beavis Schock. He's in private practice in Clayton at Schock Law. We're also joined by Nicole Gorofsky, former prosecutor in both state and federal court. She's now at the Clayton firm of Frankel, Rubin, Klein, Payne, and Podlowski, PC. And we're also joined today by Eric Banks, a former city councilor for the city of St. Louis, and he is now an attorney and mediator at Banks Law. So I want to talk about Dr. Brown's suing Dr. Brown's. The St. Louis Baby Bottle Company is suing the New York Soda Company. The St. Louis company that makes baby bottles, they want to start selling electrolyte drinks, like to give them to like toddlers. Like maybe if you're ill, you get like a Pedialyte. Well, you could get something from Dr. Brown's, which is sort of the gold standard baby bottle company. Now, the soda company had sent them a cease and desist. They said there's too much likelihood of confusion. You're selling drinks, we sell drinks. This is sort of a preliminary step before filing a trademark lawsuit. Well, rather than wait to be sued, the St. Louis Baby Bottle Company went to court. They're seeking a declaration that there would be, quote, no likelihood that any relevant consumers would be confused, mistaken, or deceived by this electrolyte drink. Eric, this just feels unusual to me that rather than the soda company suing to stop them, that the baby bottle company is suing to get out ahead of being sued. What's going on here?
A brilliant example of lawyering, and the fact that my former partners at Thompson Coburn brought this lawsuit on behalf of the baby bottle company has nothing to do with my prognosis. But they won the race to the courthouse. Instead of this case being tried in New York, where the defendant is presumably domiciled, it's going to be in the plaintiff's own backyard here in St. Louis.
And why is that a good thing?
Because home field advantage is alive and well. It's just psychologically sets you up to be in a better position when you're on your home field.
Does that have to do with because you're knowing the judges, you're hanging out with them, or is that more like, hey, I know Missouri law, I don't have to fly in, I know how all this works?
Both.
Okay.
Yeah, both.
Yeah.
And I mean, just as a St. Louis person, don't you want to root for the St. Louis company?
I'm already on the side of the baby bottle guys.
I think sometimes judges feel the same way. They're people.
Yeah, that's interesting. So they get the jump. This is now going to be unfolding in St. Louis. But they're not asking for a jury trial. This is not like Beavis's Sunflower Man. What are they trying to have happen here?
Well, they're trying to get a judge to look at the facts and look at the pleadings and then decide for the plaintiffs without a jury. And declaratory judgment actions don't have juries. So it's perfectly permissible for them to go on that strategy.
Is this just a little cheaper to say we just want the judge to sort this out, or not necessarily?
I think at this level, it does not make any difference.
Nothing's cheap.
I think that these folks have money to burn.
Yeah. Beavis, what do you think of all this? Would you do this proactively, try to get that home field advantage and ask for a declaration from a judge, or are you going to tug at the jury's heartstrings?
Well, in this kind of case, as Eric said, it's a trademark infringement. The question is whether the public's going to be confused. And under the way things are set up in federal court, you don't get a jury for that, period. That's not going to change. I mean, I wish you did, but you don't. Because I think whether there is confusion is the kind of thing a jury should sort out, not a judge.
But honestly, it feels like we're more equipped as non-lawyers to sort out something like this than like medical malpractice. I can tell you whether I'd be confused.
I think the home team's going to lose this one the way the Cardinals got beat by the Cubs.
Whoa, now tell us why.
Well, I think it's confusing. They're both selling stuff that kids drink, and that's what the New York people have been doing forever, and that's what our people want to infringe on that. I think they're going to lose.
Well, selling things that kids drink. Kids aren't supposed to drink soda. We're talking about a drink here for toddlers.
I thought you were a mother and know the truth.
I don't don't know. I try not to let my kids have soda. Does this make me a freak? My kids think this makes me a freak.
So it's obviously a controversial topic, and I'm just teasing, but I think it's a very, very hard case for the local people.
Because here they are getting into the drink business. That's the fundamental problem.
As I see it, yes.
So
It's excellent publicity. I mean, I never heard of this baby company before this case, and now they're getting national publicity.
I will say we broke this story at St. Louis Magazine, where I'm now an editor. We heard from multiple locals who were like, oh, I love Dr. Brown's baby bottles. I had no idea that here they are right in South City. This is a St. Louis company. They now have this hometown pride and this very good product that Dr. Brown's puts out. So, yeah, maybe this is better than a press release.
Yeah. Oh, yeah, without a doubt.
But so Beavis alluded to this issue that this New York company has been doing this forever. The New York Dr. Brown's that makes these like old-timey soda bottles, they date back to 1869. Dr. Brown's, the St. Louis company, it was started by a guy named Dr. Brown. This was in the 80s. Nicole, does that make a big difference here?
I mean, I'm not a trademark law specialist, but I think when you're talking about whether or not whether or not the public is going to be confused, I think you might look at how long somebody's had a market share and how long they've had their name out in the public sphere. I think it could be relevant. I don't necessarily think it's dispositive, because I think what's really more important is, whether people associate Dr. Brown's baby bottles and electrolyte solution with, is it really getting too close to the soda or not? And Beavis might be right. It might be too close, because, of course, all these soda companies now make electrolyte drinks, too. So
that's a good point.
It may be an issue.
One of these that we had talked about maybe a couple years ago at this point, Mission, the maker of tortilla chips that you can buy all around the nation, they sued our own local Mission Taco Joint. And Mission Taco Joint, it's a restaurant, but they were getting into they wanted to sell to-go jugs of their margaritas, which, for the record, these are terrific margaritas. I can see why they wanted to get into this business. Well, it was when they started trying to sell a retail product that Mission, the chip company, is like, whoa there, you can't do this. And I remember there being a lot of discussion from our panel, like, is that confusing? Is that not confusing? Well, the outcome of this is that the taco joint, the case was settled, but they changed their name as part of the settlement. That's a huge step. This would be a huge step if Dr. Brown's had to change their name. It was founded by Dr. Brown. That doesn't seem fair.
The local company doesn't have to change their name of their bottle company. They have to start up a new division with a new name and put the electrolytes in whatever bottle they want.
But they want to build on the good brand that they've built. Everybody loves Dr. Brown's.
That's what the other company's been doing for 120 years, and they are entitled to do it.
Well, Beavis does take a grim view of this case. Eric, do you feel more bullish on the part of your former colleagues and their client?
I think it's worth a shot. Yeah, I think it's it is a coin toss, and whenever it's a coin toss, you need to settle.
So our producers remind me that there was this sort of infamous St. Louis case, the brand, the North Face, that makes fleeces, like the one Nicole is wearing today in August.
It's freezing in here.
It is freezing in here. That they, there was a local group of, I believe they were like young men with a juvenile sense of humor. They created a company called the South Butt. And this led to a cease and desist, because you couldn't make fun of the North Face by having the South Butt. To me, that feels like how could you be confused by something that's a clear example of parody?
That's not what happened at the outcome. The outcome was that Jimmy Winkleman, this kid who's now a PhD in chemistry or something and has a lab of his own and is doing great, was just made a little money on it. They knew they were going to get harassed to death. And that was the end of it. They just gave up.
I will say, as all cases in St. Louis that are just absolutely bonkers, it did not involve Beavis Schock, but it did involve Al Watkins. One of those two lawyers are involved in all of these, and that
you can leave my name separate, far from his.
So So, all right, switching to a more serious note here. The police board that governs the St. Louis Police Department, this is a state-appointed board. It answers to Governor Mike Kehoe, not the mayor. They have lost more than once in court this summer. And I think the big question is, what's this going to affect going forward? So the police board had sued the city, proactively seeking a judgment that they were entitled to not just 22% of the general fund, but also 22% of the city's reserves, 22% of the Rams settlement funds. Boy, residents of the city of St. Louis were not happy about this lawsuit. Everywhere I went, people are like, what is going on with this lawsuit? Well, this police board lost 3 different times on that question since this legal roundtable was last in session. The first time was before Judge Joan Moriarty. She wrote, quote, "The court finds that general revenue only includes current income of the fiscal year in question. It doesn't include income from prior years, and that uncontradicted evidence shows that both the Rams funds and accumulated reserves are just that." Nicole, this kind of feels like a no-brainer. Like, this is the one where you could look up in the dictionary, like, what does revenue mean? Is it that simple?
I think it is that simple. I think that there's another interesting point, which is the attorney who represents the police board gets a 40% increase in his fee if cases get litigated. And obviously, he's the one who brought this case. So I think, that definitely plays into it.
It does make you wonder. I mentioned that the police board lost 3 times. So that was the first one before Judge Joan Moriarty. So the police board then appealed. They appealed simultaneously to the Court of Appeals and the Missouri Supreme Court. Both of them said no. And then it appealed a different way to the Court of Appeals. Beavis, as a reporter, this is not something I had ever seen, that they tried to do simultaneous appeals. Is this something I'm just missing out, that y'all do this all the time?
No, the rules of the game are, in the middle of the case, you can file for something called a writ. That's what I did on the Sunflower case. Very few get granted all over the world. But the appeal happens at the end of the case. So I think what happened is that Mr. Graville,
again, lawyer for the police board, kind of tried to do everything at once, and he came up with an offer. And it kind of felt like the appeals court, I don't know if I'm like reading between the lines, it felt like they were kind of like, whatever, like, you can't do this. Like, here's the proper way to do this. It felt like their nose was a little out of joint. Eric, do you think I'm reading that right?
I think that's accurate. Yeah, I think it's accurate.
So I guess bigger picture, that lawsuit was unsuccessful. But in the final appellate court ruling on this, they were like, look, there's a better venue to settle this. And this is the lawsuit that the city already filed to try to sort this out. So that lawsuit is ongoing. I know the city councilor's office is working hard on that. But at the same time, Arch City Defenders had previously filed a separate lawsuit challenging this state takeover. They've already gotten a verdict in circuit court, and it is a verdict that says, yeah, the state was allowed to take over the police board. You can't mandate that they pay all this money for insurance for the rest of people's lives, but this state law was constitutional. Beavis, how does that affect things? The fact that you have this ruling on something brought by like a third-party group, is that going to have a big impact on the lawsuit that was filed by the city that deals with some of the same issues in a different venue?
I think this is a super complicated case, and I don't really know how it's all going to come out. It's like the river delta of the Nile. It's going in lots of little branches, and who knows on any given day which one is going to be to have the most water and get through it. So I have no idea what's going to happen, although I will say I think the police board takeover will continue to exist. I think that's going to be how it is going forward. I don't like it, but a lot of people do. I think it'll end up staying.
It will survive this legal challenge, is your prediction?
Yes.
The existence
I
of
think
it.
to add to what Beavis said about it's got all these little, tributaries and different cases coming off of it. I think if you're, as a practical matter, if you're an attorney and you go to court and you hear, these attorneys arguing on these cases, I think they're confused too. No joke. The judges, I've been in court and watched some of these. Yes, and the sides are trying to argue mundane law, and the judges are like, who's in control here? And I think it is as messy as it seems.
Yeah, it has certainly been a messy spring, messy summer vis-a-vis the state takeover. I think it's been fascinating for those of us on the outside looking in, realizing like how many complicated things in terms of liability and who pays for what, that it doesn't seem like the state legislature like fully worked through when they passed this law.
There's kind of a contradiction, too. I think we all understand crime is terrible in the city. We need more police to stop the crime, but we don't want to spend more money on them. That's an internal contradiction.
I don't know that that's something that every city resident would agree on, Beavis. But that might be a debate for a political show rather than a legal show. Eric, I'm going to give you the last word on the police board matter here. This is I love Beavis's metaphor about the delta of the River Nile. What's your take on this waterway that we look at ahead of us?
I agree with the great judge, the good judge. I don't think that these revenues should be counted for purposes of the allocation of the police board's budget. But other than that, it is just a real sticky wicket, and it's going to take years of litigation to get this sorted out.
I think that Eric has given us the word on this that is unimpeachable. And we are talking today to our legal roundtable. That is attorney Eric Banks. We're also joined by Nicole Gorofsky and Beavis Schock. We're going to take a quick break, but coming up next, we'll talk about judges running their mouths online. This is St. Louis on the Air on St. Louis Public Radio.
If you have a smart speaker, you have access to the entire world of NPR and St. Louis Public Radio. All the latest news and all the captivating stories. Activate our voices with yours by telling your smart speaker to play St. Louis Public Radio.
Welcome back. I'm Sarah Fenske. I'm here with our legal roundtable, three experts helping us understand the law. Today, that is Eric Banks of Banks Law. We're also joined by Beavis Schock of Schock Law and Nicole Gorofsky, a partner at Frankel, Rubin, Klein, Payne, and Podlowski, PC. So another judge in St. Charles County is in trouble, but this one did not dress up like Elvis. Some of you may remember that memorable episode that we talked about. Instead, Wentzville Municipal Judge Michael Carter just shared a lot of opinions on social media. He apparently owned no fewer than 5 Facebook pages where he ginned up discussion. He also had a popular online talk show called Justice and Journalism. I don't know who the journalist was because it sounds like he was interviewing public officials. Maybe he was a judge and a journalist. Well, he's also now accused in these Facebook groups of, quote, mocking criminal defendants, endorsing political candidates, doubting if women who use drugs can be victims of sex crimes, and making statements that could impair the fairness of active court cases. So, Nicole, I'm going to lob you a softball. Why is this a problem? Aren't judges supposed to judge?
I mean, the problem is if judges start getting into stating opinions that can affect the way people feel coming before their court. For example, if they think, oh, the judge has already made a decision on this case that he's going to hear, before he even hears it, because he's already espoused that opinion out on social media or in the media, that's a problem. Then, of course, the court also says, it diminishes public trust and confidence in the judiciary and diminishes, the office. So obviously, these are things that you're not supposed to do. And really, I think when he gets even more specific about mocking the criminal defendants and saying things about, victims of sex crimes, I mean, that's really crossing the line. That's really getting into cases that could come before you.
Eric, do you think he could have gotten away with, he's hosting Justice and Journalism, he's moderating these Facebook pages, and they're just kind of talking about current events. He's sharing how he feels about President Trump and Kamala Harris versus talking about women who use drugs?
I think his behavior is beyond the pale, but I also think it's consistent with the way he's been for the last 15 years. So what the Wentzville public sees is what they get.
So that's interesting. You say this has been going on a while, yet it seems like this has only now come to a head. Any sense of what's changed?
Oh, I think tolerance with his antics. I think that they've given him enough rope in which he can hang himself with, and the sooner he is hung, the better.
Metaphorically speaking, of course.
Yes, of course.
Now, Beavis, you're known as a contrary voice. I'm wondering if you feel like what this judge has done here is appropriate.
It's terrible. No contrary today on this one. I will say that my clients come from all walks of life, from the richest members of this community to the poorest. And all of them, in my experience, accept what judges say. I think everybody in society understands we need a dispute resolution process. The people who say in their mind, I would like to be a judge, that's quite a thing to say, because you get to make these incredibly important decisions and people have to follow them. But as a society, we need to have that process, and there has to be respect for a judge. So if a person like this gets on the bench and makes a mockery of the system, it makes it so that people at all walks of life will not accept what the judge says, and that is terrible for society.
Wow, can I go on record as agreeing with Beavis today?
Hell has frozen over, and Nicole and Beavis are in agreement. I'm still not in agreement here. Now, I do have more of a devil's advocate type question. I know that when I deal with judges in the St. Louis area, they do not want to talk to journalists, and I respect that. It's like it's just common knowledge. You try to call a judge to talk about a case, and they are never, ever going to take your call. They don't want their name out there that way. That's great. But I see the Supreme Court justices, who I also have a ton of respect for, they are writing books. They are giving public talks. In some cases, they seem to be almost like wading into some of the issues of the day when everything ends up before the Supreme Court. How is that different, other than that it's so much more erudite and they're not doing it in this tacky way that our Wentzville friend is, but they're sharing some opinions.
I want to tell you how much I agree with Nicole here. What she said about the mocking of a defendant is over the line. These other things are just terrible. These judges who write books, they write about the law and how wonderful it is, and the history of the law and what trend lines are. These are all things that are appropriate to discuss as opposed to what's going on here.
Eric?
I agree.
Wow, we have a unanimous panel here. Okay. Yeah. So, Nicole, I want to just ask you one last question about this case. So this same state judicial ethics panel that pushed Judge Matthew Thornhill, the Elvis judge, to take an early retirement, they're now investigating this. They've filed a complaint that lists more than 24 instances of wrongdoing by this Judge Carter. They're recommending that he be removed from the bench. What can you tell us about what will happen next?
So they make a recommendation, and then the Supreme Court takes it up, and they make the ultimate decision, and the judges will review it, and I think he will have the opportunity to present some arguments and be represented. But I do think ultimately the Supreme Court is going to find this to be as problematic as our panel finds it to be today.
And so they have the final say. They're sort of like the self-policing mechanism of Missouri courts.
Yes.
Okay. Well, we will probably be talking more about this one, and you guys can again school me in why judges cannot do these things. So this is a very tragic case here. A St. Louis woman was sentenced to probation after she failed to save her daughter's life. The Post-Dispatch reports that Lori Grayson admitted to not caring for her daughter's diabetes. She neglected to take her to the doctor for scheduled appointments. She didn't even fill her prescriptions for insulin. This went on for 13 years. This child was 13 years old. This went on for several years after she was diagnosed with diabetes. This young girl, Giovanni, died. And so the mother here was charged. She ended up pleading guilty to 2 felony counts of endangering the welfare of a child. Nicole, you're a prosecutor. Have you ever seen a case like this where you see it wasn't that the parent beat the child? It was like the sin of omission. It's what they didn't do.
Yeah, I was even a child abuse prosecutor. I can't say it's a super common type of case, but I think it comes up, and I think it's absolutely necessary. I mean, a child, obviously, in a parent's care cannot, go to the pharmacy at 13 years old and get their own prescription. Like, this child is 100% dependent on the parent, and child endangerment is literally the offense that's made for this kind of problem. I think it absolutely happens, and I think it's horrible, and I think this was decided correctly.
Are you surprised to see her sentenced to probation? I mean, if somebody has, endangering the welfare of a child to the point that the child dies, is that a probation case?
I mean, I'm going to speculate that this mother probably had no criminal record and probably came forward and said, how, horrible she felt and she had lost her child. And I think, she probably threw herself on the mercy of the court. And I think, that's the sentence she ended up getting. Do I think it should have been more harsh? Personally, maybe I do. But I think, that's probably what happened.
Eric, any thoughts on the appropriateness of this punishment?
Oh, I think it's quite appropriate. I think that this is the type of case that probation was made for.
Beavis, any disagreement?
Well, I think there are lots of people who are not following the medical advice that if we're going to put everybody in jail who fails to take their prescriptions at the moment the doctor said, we're all going to jail. And I think this lady didn't know that this time would be the time the child would die. I mean, if there was something about it that was acute that particular time, it's worse. But I agree with Nicole again.
Nicole?
Yeah, I mean, I think we can talk about there's a spectrum of these things, right? There's parents out there that, Beavis probably would be happy to represent who don't want to take certain vaccines or any of those kinds of things. But, in this case, you're talking about a child who has diabetes. Insulin is very clearly a necessity for life. This isn't in the middle of the spectrum. This is very easy. This is not a parent like, oh, I didn't give my kid, some Advil when my kid had a fever. This is a necessity for life, and the parent didn't give it. And the parent also, when the child was vomiting and unfortunately dying in front of her, the mom left the house and went out. So, yeah, no, this is not that situation. It's not in the middle of the spectrum. This one was not a tough case.
So just in our final couple minutes here today, there's a shooting in Lindenwood Park that had armchair quarterbacks playing lawyer this month. Timothy Kemper allegedly shot 2 youngsters he saw rifling through his car. He's now charged with murder. Eric, many people online seem to be sympathetic. Are you?
And I was one of them until I got into the facts of this case. And it's clear that the Castle Doctrine does not allow for the use of deadly force to save a inanimate object. And there's a lot of things that aren't, I have not uncovered yet. One was, where was the defendant when he shot the shots? He obviously was not in the car, and there was no family members in the car, so that the Castle Doctrine does not apply.
And the Castle Doctrine would say he'd have to have some fear for himself or his life?
Fear for himself, his life.
Nicole?
I mean, so to be clear, the Castle Doctrine basically says if someone breaks into your home, you are not required to retreat. So you can, you can do what you need to do to get that person out of their home. To use lethal force, you have to have fear that your life is in danger, even if it's in your home. But I think it's a much easier case when someone breaks in your home. You're going to feel like your life may be in danger. So apparently the facts of this case where the guy was up in a second-story window shooting down from the window.
Ooh, that's not a good fact of the case.
That's
I can see
not
how
a good fact.
Eric's changing his tune.
Yes, and so just in defense of your property, you can't use lethal force like that.
Beavis, let's say that I'm sitting in my car and some guy is breaking into my car while I'm in it. Could I pull out a shotgun and blow the guy away?
Absolutely, and there was a case out in St. Charles, which is just like that a month or so ago, and it's very fact dependent. Was the guy trying to break in the car or not? We do have an issue in society. I mean, there are 2 ways to have a sensible society. One is to have people act morally, living in ordered liberty and respecting each other's property. The problem we see is these waves of crazy mobs of people committing crimes, breaking into cars all over town, and that's ineffective. It's why people move to the country. They get away from the city because they don't want to be around it.
It is probably why the online commenters are saying what they're saying. But Nicole, we want to make clear for people who are listening, it doesn't matter the frustration you feel if somebody's breaking into your car.
Right. Can you imagine if we allowed lethal force for, lesser and lesser reasons? It's a slippery slope. We'd have people running around shooting people all the time. It would be a horrible thing. No, this is a very important law, and even Missouri, which is very gun friendly, doesn't allow you to use lethal force just in the defense of property if you do not feel some sort of threat to your life or health.
And the way that the law has sorted out, if I'm on my second story, looking down on my car, I can't say that I'm afraid for my life.
The facts could be different if someone was pointing a gun at you in that second floor window, but I don't think that is turning out to be the facts in this situation.
That has not been a fact pattern I have heard alleged. Well, we'll see what happens to this case as it shakes out. And I want to thank our panel. We've had some good agreements and some good disagreements, too. Nicole Gorofsky of Frankel, Rubin, Klein, Payne, and Podlowski, thanks for joining us.
Thank you.
Beavis Schock of Schock Law, thank you.
Thanks for having me on.
And Eric Banks of Banks Law, thank you so much.
Always a pleasure.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Hi, I'm Laura Hamden, and my colleague Jessica Rogan and I are your daily hosts of the Gateway newsletter. We meet with the editors in the STLPR newsroom every weekday to bring you the top local stories of the day in a quick and easy 6-minute read by 6 a.m. In an age of overwhelm, it's a refreshing, thoughtful take on the news day, if we do say so ourselves. Fine-tune your daily news habit with the Gateway newsletter. Subscribe at stlpr.org/gateway.